Major breaking news out of the United States District Court for the Southern District of New York, believe it or not, in the case of Mark Lane versus Rocha against the state of New York involving New York's quote-unquote assault weapon ban dealing with semi-automatic rifles and AR-15s. A huge motion for summary judgment has been filed on behalf of the Second Amendment and the plaintiff suing the state of New York on behalf of the Second Amendment. Big time argument here. Great brief has been submitted laying out exactly why the New York ban on so-called assault weapons, which are really nothing more than ordinary semi-automatic rifles, is clearly unconstitutional under the Second Amendment's text and Supreme Court precedent. A powerful brief, a winning brief, has been filed. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books on the Second Amendment, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. And I was just looking at the draft book cover today of the next book, so you're going to see an announcement very soon on the next book. All right, folks, big news here. Powerful legal brief. I'm going to put a link to it down below in the description. In the case of Mark Lane et al. Versus Miriam Rocha et al. Against the state of New York. Specifically, New York has banned semi-automatic rifles, AR-15s, and the like. This is a challenge to that law because the plaintiffs say they want to be able to buy AR-15s like every other American can across this great country outside of a few terrible anti-gun jurisdictions in those blue-controlled, blue state, Democratic-run places like New York, New Jersey, California, and the like. Now, this is a powerful legal brief submitted on behalf of the Firearms Policy Coalition and the Second Amendment Foundation and the individual plaintiffs in this case. It lays out beautifully exactly how you can easily win an AR-15 ban case. It makes all the points that I think you've heard on this channel before. It talks about, for example, the in common use test. It talks about the Staples case, the Supreme Court decision. It also talks about the Caetano case. And, of course, it quotes a very handsome YouTuber by the name of Mark Smith and his Harvard Journal of Law and Public Policy explaining exactly how to apply the in common use test. All that stuff was put together in this legal brief. I highly, strongly urge you to take a look at it if you have the time. It's a nice work of advocacy here. Now, again, just to remind you the way it works, that the text of the Second Amendment is prominent. So when you talk about shall not be infringed, we start with the text. That's what the Supreme Court says. It makes a lot of sense because the ultimate historical document of them all when it comes to American law is the U.S. Constitution. And part of that U.S. Constitution is, of course, the Second Amendment, which in relevant language reads, the right of the people to keep and bear arms shall not be infringed. Obviously, if you're banning a type of firearm, any kind of bearable firearm, such an AR-15 or semi-automatic rifle and so on, these are clearly firearms and thus they are arms. This brief here on behalf of the Firearms Policy Coalition, the Second Amendment Foundation, makes this exact point. They talk specifically about how anything that can be used offensively or defensively is an arm, and that obviously would include firearms such as AR-15s. Here is what the Second Amendment plaintiff said, making this exact point. Bruin explained the Second Amendment analysis starts with the text, and that is what the court did in District of Columbia versus Heller. The key aspect of the text at issue here is arms, and evaluating founding era dictionaries, Heller interpreted arms to mean weapons of offense or armor of defense. Arms thus includes anything that a man wears for his defense, or takes into his hands, or useth in wrath to cast at or strike another, and it unequivocally includes all firearms. New York's ban therefore implicates the plain text of the Second Amendment. That's exactly right. The plain text is implicated here, and then you know what happens. What happens? The burden shifts to the government to come forth to show their historical analog laws that would justify the modern-day gun control law. Now, when you're dealing with an arms ban case, which this AR-15 ban case in New York of Lane versus Rocha is an arms ban case, the good news is that historical work has already been conducted by the United States Supreme Court in the Heller case, because Heller dealt with an arms ban law, specifically the District of Columbia's ban on all handguns. So the Supreme Court obviously said that handguns are part of the definition of arms textually. They shifted the burden to the government in Heller, and then they looked at the historical evidence of when can you possibly ban an arm in America going back to the founding. And of course, the Supreme Court said that there's really only two historical strands of historical laws that speak to arms that potentially, mind you, could be banned. The first category of laws, of course, is the militia laws that say specifically that ordinary Americans at the time of the founding would have to bring their ordinarily, commonly owned weapons that they had on their farms or whatnot with them to militia musters. So if you had a Kentucky long rifle or if you had a Brown Bess musket, and that's what you owned, you could bring that with you to militia musters along with ammunition and so on, the powder and cartridges and so on, that you also had at the home. The point being that the Supreme Court says, well, that means obviously if there's arms that are commonly owned by Americans, those must be protected because you had to have those privately owned arms in order to come and bring them when you were called out for militia musters. And that means that anything commonly owned suggests strongly the historical tradition is Americans at a minimum get to own arms that are commonly owned. But beyond that, it talks specifically in the Heller case that there is some tradition in the common law of allowing bans on the carrying of dangerous and unusual weapons. Dangerous and unusual weapons. That's a conjunctive test. They must be dangerous and unusual. And by extension, of course, the Heller court said that something that is in common use by Americans for all lawful purposes or for any lawful purposes, it cannot be dangerous and unusual because guess what? If it's common, it's not unusual. And if it's not unusual, it can't be dangerous and unusual. It just makes a lot of sense. In fact, in a press release set out by the Second Amendment Foundation, that is exactly what they talk about when they discuss and summarize this filing they made in the Lane case. Executive Director of the Second Amendment Foundation, Alan Gottlieb, had this to say. As noted in the brief, because only dangerous and unusual weapons can be banned, it follows that arms in common use at the time are protected by the Second Amendment. After all, an arm that is in common use cannot be both dangerous and unusual. Wow, that sounds familiar and exactly right. This is perfect analysis. This is absolutely correct. You don't need to learn it from the four boxes done. You just have to read the Heller decision. But of course, a lot of people in the anti-gun community don't like the Heller decision. And as I've explained to you before, they like to pretend that Bruin is the only Second Amendment case out there and the Heller case doesn't exist because they want the opportunity to revisit these historical analog laws and make stuff up and come to the conclusion that, of course, you can ban guns, which clearly you cannot do so based on the Heller precedent. And that's why the anti-gunners like to pretend that Heller is not the law of the land, that it was somehow superseded by the Bruin case in 2022. But that's simply not the case. As I point out in my article in the Harvard Journal of Law and Public Policy about the in common use constitutional test, the reality is that Heller and Bruin are both the law of the land. Heller and Bruin do the same exact methodology. Heller dealt with an arms ban case. Bruin dealt with a may issue discretionary licensing regime, but they still use the exact same approach, the same interpretive methodology of the Second Amendment. And of course, the constitutional test when it comes to Heller is if it's in common use, it cannot be banned. And of course, in Bruin, the issue is if it's gives rise to discretionary subjective licensing regimes, giving government agents the authority to determine who is good enough or who's not good enough to have a gun, that's a no-go under the Constitution because it gives the government too much discretion to decide who gets to exercise their rights. And that's not how we treat constitutional rights in America. You don't have to go mother may I to a government official to do mass on Sunday, for example. Let me also add a quote here by the Second Amendment Foundation's Executive Director, Adam Kraut, and this is what he says. Because modern semi-automatic rifles are not dangerous or unusual, and because they are commonly owned, the court should grant judgment in plaintiff's favor, declare the firearm ban unconstitutional, and enjoin its enforcement. Powerful language there by Adam Kraut, and I could not agree more. But let's carry on and talk a little bit more about the brief. Again, as we already talked about, this brief points out that arms falls within the plain text of the Second Amendment. That shifts the burden to the government. And again, what does it require the government to do? Once it shifts the burden to the government, of course, that's where the historical analysis comes into play. Now, we know that the anti-gun movement wants to elevate all historical questions to the text of the Second Amendment, to the plain text question, because the burden still lies at that point as a matter of pleading law, what you plead in a complaint, with the plaintiffs that support the Second Amendment. So the government never wants the burden to shift to them because they know they're going to almost always lose because the historical tradition of gun regulation in America is very scant. It's very few laws at the time of the founding because why would a group of men enshrine the right of the people to keep and bear arms in a constitution while at the same time create a whole lot of restrictions upon it, that would make no sense. So the fact that there's very few gun control related laws at the time of the founding is entirely consistent with the ultimate historical document, the Second Amendment itself, which, don't forget, is a historical document. Now, with that said, this is how the Mark Lane plaintiffs in support of the Second Amendment explain how the history works at that step 2. Plain text, burden shifts, and then you go to the historical test, and here's how it's explained in this brief. As Bruin explains, once the plain text of the Second Amendment is implicated, the government bears the burden to establish that the challenged law is consistent with the nation's historical tradition of firearm regulation. Here, however, Heller already has determined what the applicable tradition of firearm regulation is in a case involving a ban on certain types of firearms, the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Because only dangerous and unusual weapons can be banned, the government bears the burden. The government bears the burden to show both that a banned weapon is dangerous, i.e. that it has uniquely dangerous propensities, and that it is unusual, i.e. that it is not typically possessed by law-abiding citizens for lawful purposes. There is a necessary corollary. There is a necessary corollary to this dangerous and unusual test. Arms that are in common use are protected because such arms, by definition, cannot be unusual. Exactly right. Exactly right. That is exactly how to explain it. We've talked about this on this channel before, and the Second Amendment Foundation and the Firearms Policy Coalition in this powerful brief on behalf of the plaintiffs in the Lane versus Rocha case are doing a great job making this exact point. These are arguments that if they get to the U.S. Supreme Court, and hopefully they do in the Bianchi case, fingers crossed, they will win in front of the Supreme Court. The issue is, can we get an AR-15 ban case to the Supreme Court? Will they take it? And if they take it, we're going to win it. That's really the big question. But let us carry on and talk more about this powerful brief. Well, of course, we don't want to beg the question and ignore the obvious, the elephant in the room, whatever metaphor you like. We also obviously understand that semi-automatic rifles, AR-15s, are ubiquitous. They're everywhere. In fact, they are so ubiquitous as this is why anti-gun politicians like Chuck Schumer and the like to run around and say there's too many of these weapons of war. Well, there are too many because Americans decide to buy these AR-15s and these semi-automatic rifles for all sorts of lawful purposes, including self-defense. So there's really no dispute that these are commonly owned. They've been commonly owned for literally decades, right? These are not exactly new weapons. And we as Americans own tens of millions of these. But let's just see how this brief in the Lane versus Rocha case on behalf of the Second Amendment Foundation and Firearms Policy Coalition, let's see how they sort of summarize why it is the case based on the evidence that AR-15s are commonly owned, commonly used by Americans for lawful purposes. These principles resolve this case because New York bans common automatic firearms, the paradigmatic example of which is the AR-15 type rifle, the most popular rifle in American history. AR-15s and similar semi-automatic rifles are the second best-selling firearm in the country of any type behind semi-automatic handguns at approximately 20% of sales, and they are overwhelmingly owned for lawful purposes such as self-defense, training, and hunting. New York simply cannot show that firearms that are the most popular in the country are dangerous and unusual. Indeed, the Second Circuit in New York State Rifle Association versus Cuomo in 2015 found that the banned firearms are in common use as that term was used in Heller at a time when approximately 4 million AR-15 and similar rifles had been manufactured. Today, that figure is well over, or is over 28 million. Well, of course, these AR-15s and semi-automatic rifles are ubiquitous and they're commonly owned. I should also just note before I wrap up, this brief talks about two other important Supreme Court cases. We've discussed the Staples case, which drew that distinction between automatic rifles, I should say basically machine guns, fully automatic weapons, and semi-automatic rifles. And in the context of the Staples case, the Supreme Court says that, we all know that AR-15s are commonly owned. People own these all over the place. And that was a Supreme Court decision from the 1990s. Also, this brief talks about the Caetano case, which I'd like to think that I helped bring that back to life. A lot of people were ignoring Caetano versus Massachusetts, but I think it's a very important case because it has a lot of propositions in it, including that arms other than firearms are protected because it dealt with stun guns. Stun guns are not firearms, and it shows that the Supreme Court thinks that other arms other than guns are protected, such as stun guns. So that is a reason why I think Caetano is important. It's also important because of that Justice Alito concurrence, where he talks about dangerous and unusual being a conjunctive test. He talks about what Heller meant, how to understand it, and of course he points out that stun guns are in common use because approximately 200,000 of those were sold. And whenever you're talking about AR-15, semi-automatic rifles, or magazines holding more than 10 rounds, although the Lane case doesn't deal with magazines, the idea, of course, is however you look at it, the numbers of these guns out there are orders of magnitude larger than 200,000, which is really the baseline that Justice Alito's concurrence in Caetano was talking about. And last but not least, of course, this brief does wisely cite to my article in the Harvard Journal of Law and Public Policy. If you haven't read it, take a look at it. The real reason why that article about in common use was written by me and I try to promote it is because it really takes on the typical anti-gun response to these cases involving arms bans, where they try to pretend that these new guns like AR-15s are some sort of unprecedented societal change or unprecedented technological change or something like this, and they try to use that as an excuse to get around the compelling, clear, unequivocal, and binding Supreme Court precedent of Heller, and my article lays out in extreme detail why that's simply not the case. And it talks expressly about how in 2007 you had the Virginia Tech mass shooting with the semi-automatic handguns with magazines that held more than 10 rounds, and dozens of people killed at Virginia Tech in 2007. And despite that being discussed by the Supreme Court in the briefs in the Heller case, the Supreme Court issued the Heller decision in 2008. So anyone that tries to suggest that mass shootings or semi-automatic weapons are somehow new unprecedented technology or new unprecedented societal changes that the Supreme Court was unaware of or did not think about when they issued the Heller or the Bruin decisions, that's simply balderdash, because again, the Supreme Court was well aware of the 2007 Virginia Tech shooting and the mass shootings that occurred before 2007, but certainly the Virginia Tech shooting was literally briefed to Heller right there less than a year after the Virginia Tech shooting, and the Supreme Court, was aware of it and issued the Heller decision that says, regardless of all that, regardless of how guns can be misused, that's not how we measure constitutional rights. And the bottom line is, at a minimum, if an arm is in common use by Americans for a lawful purpose, it cannot be banned. By the way, there may be other ways that we protect arms. In other words, if it's in common use, it is sufficient for our side to win. That doesn't mean it's the only way to win an arms ban case, but it is the easy and obvious one. It is the layup, no-brainer way to win these cases today when you're dealing with AR-15 semi-automatic rifles and magazines holding more than 10 rounds. Although the Lane versus Rocha case is really only dealing with AR-15s and semi-automatic rifles. Magazines does not play a role in this particular case. So there you have it. So let's see what happens. I'll keep you informed of this Lane versus Rocha case that's in front of a very strong judge, Judge Kenneth Karras, who's ruled favorably in favor of the Second Amendment in the past. So let's see how he does on this case, on this motion for summary judgment. Only time will tell. We'll know a lot more in the next 60 days, I suspect. So there you have it. Okay, folks, hope you learned something here today. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe and resubscribe. We're trying to get to 150,000 subscribers as fast as possible on this channel. We'd appreciate your support for that. And again, we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.